and welcome to Process Bowl Studios. Thanks for joining us today, Greg. We will start with introductions on our side. I'm Gaurav. I'm one of the co-founders of Process Bolt, and with me today we have Dan Gardner. Dan, please go ahead.
I am Dan, co-founder and CIO here at Process Bolt.
And our guest today is Greg Chin from Paul Hastings. Greg, would you like to introduce yourself and give us a little bit of background?
Sure. My name's Greg, and I was the senior manager of cybersecurity for Paul Hastings. I just recently retired, but I'm still involved in a lot of the industry upcomings and goings. My job at Paul Hastings was severalfold. I ran a couple departments, but I also was specifically involved in the incoming security assessments of our clients. So I was the lucky guy that got to speak to the partners and clients about the firm's security postures, and on that note, going out to the outward, working with our vendors, particularly the e-discovery vendors, which house a lot of client data, and making sure that that their security posture was up to snuff. So been involved in the third-party risk management group at Paul Hastings for about 4 years.
Sure. Given your background, Greg, especially given your extensive background in vendor risk management and the legal industry, what are some of the broader overarching themes that you have seen emerge in the past few years?
Yeah, it's interesting because when I got involved in cyber in the past few years, what I've noticed is cyber's always been sort of an afterthought. It was something that was hooked into IT. A lot of law firms did not have their independent InfoSec department. That has quickly changed, and now law firms are starting to get very mature with that. But then within the law firm itself and the trends that go within, what we've seen recently is a real focus on third party risk. Before it was focused on maybe other things, the typical controls and firewalls and multi-factor authentication and identity access management. Now you're seeing the flavor of the month is being focused on third party because they're realizing, because of the various increasing footprints of where data can reside, the ever mounting growth of legal software that's being offered to law firms and attorneys and legal operations teams within corporations, cloud usage, they're not controlling their third parties as well. They really don't know a lot of third parties and what they're doing with their data, how their data is being housed, if they're being compliant with all the regulations. So now third party is starting to quickly mature as far as a third party risk management program. A lot of firms, I think, are still fumbling around that and trying to get that into a mature state. So I think it's quickly growing, but it's ever evolving.
Sure, that makes sense. In terms of, you said law firms, and they kind of vary on their maturity cycle. Some are already mature on the third-party risk side. Some are implementing programs. Some are at the beginning stages. So for companies or law firms that are on kind of the lower end of the spectrum, what are some of the risks that they could be exposed to? Can they be exposed to, for example, class action lawsuits? Would they be open to exposing their own customer data, in terms of cybersecurity data or personal data? Could you throw a little light on that?
Sure. I think that's the huge risk is not only PII, but we're also talking about client data. So when we engage a client, or even the firms that are not as mature, a lot of these clients require the firm to read these, they're called outside counsel guidelines. It's sort of a contract between the law firm and the corporation. And a lot of these have, high level requirements on what they can do with the client data. And so now the assessments are at a much higher level because now not only do you have, proprietary confidential data from the client, But within that matter, whatever that case they're working on, it could be some employment law matter. Now you're having PII. Now you're having Social Security numbers. Maybe it's an employment class action lawsuit that you're dealing with. Now you have all the information of all the employees of the client. So what we're seeing is a lot more stringent requirements from the clients, which is driving that for the law firm. But then a lot of law firms aren't equipped to really understand their own controls or to be able to answer the questions that their clients are asking. They don't even know whether they actually comply with the regulations that they're supposed to be requiring to comply, because the client has to comply with these HIPAA regulations. And now you're asking the law firm to comply with the HIPAA regulations, because now they're storing the same data. And then you bring that even more, the big mushroom explodes. You have the third-party vendors that are handling the e-discovery data, or maybe some other tool that's working on that data for that particular matter. Now they have to be compliant. So it's basically a lot of dominoes that are falling, and a lot of law firms may or not be ready for this big shift.
Thank you.
Where would you say the legal industry is as a whole, as far as maturity? Are we just is this just beginning, or are people getting their act together pretty quickly?
I'd say 2023 was a great year to kind of expose a lot of the issues, because not only did you have internal breaches where it was the firm's own file share. I think Oric and I think a couple other firms had. I think Allen and Overy had internal file shares that were breached. Then you also have the Move It breach. So it was a file transfer software that people are using. That's kind of evolving now. And then now we have some e-discovery vendors that I'm aware. I'm aware of at least 2 e-discovery vendors that are now involved in breaches. One of them is actually that they're getting sued on the class action.
Wow.
So where is it evolving? I say we're rounding first base, maybe.
Okay.
And I think what you're seeing now too is, like I said, it was client driven. I used to see these questionnaires from our clients, or the inquiries from our clients, or our calls with our clients.
Mhm.
And it'd be, do you have a third-party risk management program? Check that box. That's great. Now they're saying, do you have a third-party risk management program? What do you check? So now they're looking at controls. Now they're going through the list. And then recently what I'm finding is, do you have a third-party control? And then they go to the next level. How do you monitor and audit your vendors? How do you monitor and audit your own controls on a periodic basis? And how does that look like? What is it, quarterly? Is it done weekly? Is it done when needed? Do you guys look at logs? I mean, it's getting to a really granular level to what clients are asking for. So with that being said, if the clients are driving these requirements, the law firms are going to have to find a way to utilize resources. It's no longer an afterthought. They have to figure out how to utilize resources, utilize streamlined processes to get all of these questionnaires and all these inquiries from their big clients that are being sent to them. You're talking about financial institutions. They're sending their inquiries probably twice a year now. They're not waiting around for the yearly one, and some of them that I've dealt with want quarterly updates. So then you take that to the next level. You have to draw that to your clients, to your vendors. So because they're holding the same data, now you're the requirements for them. So how all these resources need to be utilized somehow, and now it's no longer an afterthought. Now you have a partner picking up the phone and saying, hey, how come we can't get an invoice paid? Because I forgot to mention this too. We've had clients that are tying their assessments to paying their invoices.
Mhm. Wow.
So
Yeah,
it's it's getting to
Yeah.
it's hitting them where it hurts.
Yeah.
So I think it's coming now to where it's going to go to round first, go to second, third really quickly, because I think it's going to hit where partners don't want it to hurt. They want to be able to maintain their clients. They want to be able to get paid.
Yeah, I mean, that whole idea of tying invoice payment to satisfaction of of assessments is kind of would be kind of game changing. That's for
Yeah.
sure.
Yeah, yeah, it's yeah, we'll see because it's definitely coming to the forefront because they know that I think as you guys know, it's the clients' fourth parties are the ones that they're really concerned about because they have no
Sure.
visibility to those clients to those
Right.
vendors at all.
Well, right. So I mean, let's pick on e-discovery vendors for a second. Uh, I imagine any sufficiently large law firm would use several e-discovery vendors.
Right.
Are you able to compartmentalize and on a sort of a per client basis say, well, for this client, we're only going to be using vendor A, and for this client, we're only going to use vendor B. So therefore, you know, talking
Yeah.
about third parties, we only concern ourselves with vendor A. Are you able to manage that, or do you kind of have to do it all as one, holistic group of vendors?
No, that's a great question. You know, I mean, best case scenario, if we have our clients tell us what vendor to use for e-discovery, then they have they have the relationship. We assume they've done their own vetting, that they've already
Okay.
put that vendor through the through the ringer, like they put the law firm through the ringer, and we're good
Right.
as gold. Uh, that's very ideal, and it doesn't happen very often.
Okay.
Um, the other part is, can you separate and bifurcate your vendors based on clients and maybe do it that way? We choose not to, and a
Okay.
lot of firms don't because then you have to monitor all the security requirements and why you're using a particular vendor because maybe this one's an ITAR vendor and maybe this one is a HIPAA compliant vendor. Maybe this one's based in Europe and so maybe it's sufficiently GDPR compliant, but
Mhm.
lawyers don't look at that kind of stuff. So when we have an e-discovery group within the law firm, they want to be able to holistically offer their their clients and their partners the same group of vendors and be able to show what the strengths and weaknesses of each of the vendor based on operations, but not based on security. So
Right.
I hope that answers your question.
Yeah, I think so. I was just wondering, is there is there that level of segmentation you can do, over and above like, it's sort of a tiering or categorization of vendors and be able to say, okay, our e-discovery vendors are holding client data, so that's top tier stuff.
Right.
Versus the people who supply the coffee, right?
Yeah,
That-
and actually, we actually hold the two-tier system not only for e-discovery vendors but all of our vendors. Client data tier one, client information also tier 1A, and everybody else, and then firm confidential information second tier all the way to the coffee guys.
Mhm.
So those are all built in and caked into the assessment, being the top tier being either client, because even client information, even though it doesn't belong to the client, that's just as critical. That's not only law firm information, confidential information, but that also can belong to the client as well. So we
Right.
want to be sensitive to that. So a lot of firms will classify their data, either it's client data or it's not client data, and they'll go to that level. And then some more sophisticated firms may have different classifications based maybe on other types of regulations, but most firms try to keep it clean because they know if they're complying with maintaining and protecting their client data and client information, that's a pretty big enchilada, and they're feeling really comfortable with that.
Sure.
Sure. So, you've described the landscape pretty well here, Greg. You know, a few years ago, there used to be a perception that, if I'm certified or if I'm compliant with a particular standard, let's say SOC 2 compliant or ISO compliant, then that's the end of the road, right? My job here is done. Anytime somebody asks me for my controls, I just hand them my SOC 2 attestation. Do you think in today's day and age, is that enough? Or As you mentioned, you have to go above and beyond where you're not just relying on that certification, you're also relying on self-reported data, you're also relying on internal controls of third parties, and you're also relying on continuous monitoring of those third parties. How would you describe the landscape shift?
I'd say yes. I mean, there's a bunch of law firms that are ISO 27001, a good number of firms, but they're still going through the assessment process. It's not just, here's my piece of paper, here's my ISO, see you next year. They're still having to go through assessments. They still have a team of people that are answering assessments, meeting with their clients for the assessment calls, answering follow-up questions. And also there's a lot of resources in maintaining an ISO, as you guys know. So it's not just having hang an ISO and hang it on your wall and you're one and done.
Mm-hmm.
So that still goes on. I think it's yes, it may make it easier. It may reduce the number of questions. I've seen clients would say, "Oh, if you have an ISO, here's another set of questions that you can answer." So it may reduce your workload in answering questions. It may be going through an assessment process, but it's not a one and done type thing at all when it comes to that. Having a piece of paper, even any other type of certification, they want to know the controls, and I think you hit a good point about how are they being monitored and audited, on a periodic basis. So that's one thing that they want to see, and not only that, I've had clients, they want to see the artifacts of that. They want to see the monitoring. We just can say, yeah, we do monitor and X and Y and Z on a quarterly basis or on a monthly basis. They want to see a proof of, maybe identity access management. They want to see people that were leaving the firm and showing the actual proof that they were actually, taken off the system and they're no longer in active directory, or whatever. So they're looking at artifacts. So it's
so you're starting to cross into full on audit mode at almost.
Yeah. Some of your clients will do that, and I think I don't think it's gonna get any easier. Mm-hmm. I haven't seen a client let up and say, "Hey, you know what? We're heading this too hard." We better back up a little bit because it's a lot of work for our law firms. Yeah, I've seen it ramp up. So, and of course they may try to, streamline their process. Oh, we're giving you, we're giving you only 600 questions that have to be answered in 2 weeks. But we're putting it in tabs, so it's easy for you to see. Well, that doesn't really help. It's still 600 questions. The math still adds up. So it's it's not going to get any easier. I think it's just going to get worse for the law firm and for its vendors.
Yeah, and and of course the old the pressure's then going to be applied down the into the third parties, the the various vendors, right? I imagine anything that a client comes after a law firm with, I mean, if they are serious, they're going to say, and what about your vendors? We have all these same expectations for anybody you're sharing our data with, right?
Right. And I'll give you an example. A lot of these these outside counsel guidelines that I was mentioning before, that clients give their law firms, say, hey, if you want to sign on with us, you just read this 50-page guideline. And when it comes to the information security section, they'll have a section that says, your vendors will comply with these same requirements. You will provide these requirements to your vendors, and you will test that they are able to comply with the requirements listed here above. So they're not even asking, oh, just assess your client or your vendors. They're, oh no, it has to be it has to be consistent to what we're requiring of you. And here it is.
Right.
You need to give it to them. So it's getting to be a lot more daunting than just say, hey man, yeah, our clients comply, or our vendors comply. We're good.
Right.
Yep. So I know we have taken up a lot of your time, Greg, today, but any last parting thoughts on this whole area, especially given your experience with Paul Hastings and how you were managing vendor risk over there? Anything? Yep.
It's interesting because my role at Paul Hastings was interfacing with the clients, dealing with information security assessments. And there's so many facets of information security, but this is one of the few departments or a few elements of information security dealing with third-party risk management is where our cybersecurity group, is interacting directly with a partner and client. So it's important. I mean, we're not the engineers on the back end. We're not the the guys doing the identity access management and access on and off. We're not managing change control or anything like that. But we have direct relationships with our clients and our partners. So that's important. So this is something to where this group has to answer directly to the guys that are making money, the guys that are bringing revenue. They're totally responsible for the operations of the law firm. So that's why I think third-party risk management is really critical. It's just as critical, if not more critical, than any other department in cyber. So you have interaction with people that make decisions. So I think that makes it a whole different level.
Sure. And just a little more thought experiment. I'm wondering if let's say you were going to start a law firm today.
Yeah.
Or join a brand new firm and be responsible for the risk management as a whole. Would you do anything differently being able to start greenfield or knowing what you know now or anything? Would you do anything differently?
No, I mean, I would probably, work on getting a good policy set. I think a policy set that can be enforced is key. I think a lot of firms, a lot of organizations may have a lot of processes and procedures, but they don't have a policy set that they can say that it's been fully enforced. But when it comes to specifically third-party risk management, I would ensure that it's tied into procurement. So being tied into procurement, so if procurement's is a company that takes all incoming purchases and vendors and agreements, then you have the contractual end of things tied in with the information security side of things. So at that point, you can make your assessment whether this vendor is part of, that will have client data or client information, or is it something that they're just, doing something that's a non-client, more administrative oriented. Maybe we can assess the risk better, whether they're going to the cloud, whether they're, whether a lot of different factors, whether it's data that's going to stay in its jurisdiction. But tying that into procurement would make it seamless. So now you're not going to have any vendors slip through the cracks, because a lot of law firms get thrown in all these applications that are supposed to help make the practice more efficient. There's a lot of stuff out there that's cloud-based now. So you have these groups called knowledge management groups and practice innovation groups that most of your large law firms have. They're in charge of integrating technology with the law firm practice. And they're getting all kinds of stuff that are really, really cool tools. And they may go, and I've seen this happen in other firms as well. They may go to the partner and go, hey, we can actually automate this legal process for you if we use this tool. And the guy goes, let's get it. Let's engage this vendor. Let's get it. Well, at times it bypasses information security assessments. It may even bypass procurement. You have a big enough partner who's a 500 pound gorilla in the room. He can make things happen, and it bypasses the whole process. Yeah. So we can't have that today. So that's definitely unacceptable today. So by integrating procurement to information security as far as part of the onboarding process of any vendor, I think that would be a good start.
Okay, that makes sense. And how about let's think about the ecosystem of law firm vendors right now. If you had one request or piece of advice to give to the common vendors of law firms, do you have anything of that nature?
Yeah, I mean, one, get your act together.
That's the big
get your SOC 2 Type 2.
Yep.
Get your independent yearly assessments. do everything you possibly can to follow, a strong information security policy. Have a policy in place that's enforceable. That's also key. I'd start there, and also make sure that the culture of the team is information security aware. I find that a lot of them kind of bifurcate their admin and a lot of law firms do, and their people that actually touch client data, but then they're actually using the same server and it's in the same in the same footprint, which is not always the greatest. So they need to take it seriously because they're actually taking client data. They're under the same requirement as our client. So if they want to do business, they're going to have to, we'd rather than have even, a more robust security controls than the law firm would have. Because then we know for sure that they're exceeding our requirements, which would make us want to use them more.
Right. And have you ever or know of anybody, a vendor that you've had to terminate business with due to insufficient controls or anything?
We've had vendors that we did not give business to because they didn't have the controls in place. So we've done that.
So okay, so there's real business impacts.
Real business impact.
Yeah.
We've had vendors that were not compliant on a couple of regulations, and so we said we'd love to give you the work. You guys do really good work, and you're actually in the same jurisdiction as the client. It would be really easy, but we can't use you.
Yeah.
So so that happens a lot, and that's why, to me, because they're such an agnostic type company where they take all kinds of client data from all different types of industries and subject to all kinds of regulations. I don't know why they wouldn't have the highest level of controls in place.
Yeah, good question. But to be fair, I wonder why some people are still like running Windows Server 2008 too. So there's no answer sometimes.
Yep. Or use Internet Explorer 11.
Yeah.
Yeah, exactly. Yeah. No, that makes sense.
All right, perfect. Well, thanks for joining us today,
Sure.
Greg.
Yeah, thank you very much.
Thank you very much. Super insightful.
Yeah, always good to talk shop, guys.